Welcome back to the channel, everybody. Thank you so much for joining me and allowing me to continue to be your daily advocate. If you're new here or you're not subscribed for any reason, please do me a huge favor and hit the subscribe button. Thank you to all of you who have been watching and following me for so long. It truly means a lot, and I'm glad that I can be this person.
As the SEC versus Ripple litigation draws to a close, the exchanges between the parties have become harsher and more detailed than they were in the earlier stages. Recent comments made by Ripple's legal counsel have prompted legal experts who are following the case to conclude that the SEC internal documents, which Judge Ned Byrne has ordered to be produced, contain information that could be harmful to the agency. Judge Ned Byrne has ordered that the documents be produced. In a video in which attorney Jeremy Hogan, a partner at the Hogan & Hogan law firm, explained the latest developments in the investigation, the evidence was referred to as the smoking gun, according to the video. As a result, attorney Hogan believes that the SEC legal positions on this matter are highly unusual, especially in light of the fact that the SEC has taken extraordinary steps to avoid turning them over, including asking Judge Ned Byrne to reconsider her decision and indicating that they intend to appeal Judge Ned Byrne's decision to Judge Torres if she does not change her mind. By the way, do you think this should be the final event enabling Ripple's win? Let us know in the comment section down below. In a previous video, he expressed his concerns that something was wrong with the SEC, saying, "There must be something really bad going on." Something that, in the end, completely undermines the SEC case. If the SEC legal gymnastics on this issue can be justified, then something is seriously wrong. He now claims that his suspicions were correct in light of this, which may prove to be correct given that the SEC previously examined XRP and determined that it did not constitute a security. The SEC used a portion of the judge's ruling in order for individual defendants to be found guilty of wrongdoing. They must have knowledge of wrongdoing to argue that internal documents relating to Hinman's speech were not relevant in this lawsuit. The SEC disagreed. In light of Judge Torres' order, it is clear that the SEC internal documents, which reflect its staff's thinking about XRP, Bitcoin, Ether, or any other digital asset, have no relevance, according to the motion. Comment, XRP Army, if you believe Ripple is about to win. However, Ripple made a significant disclosure that Hinman had potentially examined XRP and determined that it was not a security, according to the company. Mr. Garlinghouse and Mr. Larson should not be permitted to argue to the fact finder that they were reckless in failing to recognize that XRP purchasers saw XRP as an investment in a common enterprise while simultaneously concealing the possibility that the SEC-owned Director of Corporation Finance had analyzed a substantially similar asset, and possibly even XRP itself, and concluded that it was not. Attorney Hogan acknowledged the possibility of a bluff, but asserted that the likelihood of this occurring is greater than the likelihood of it occurring. According to the defendants in the SEC versus Ripple case, they want to proceed quickly with summary judgment on the two most important issues in the case: whether XRP is a security and whether the fair notice defense applies in this case. The Securities and Exchange Commission, on the other hand, is attempting to slow them down with additional delays by keeping discovery open. Such behavior, which Ripple refers to as gamesmanship, has fueled some of the harshest language ever heard on the internet, including some of Ripple's own. Keep in mind that none of the commotion and frustration has anything to do with the legal issues in the case. Ripple is attempting to move the case forward as quickly as possible, whereas the Securities and Exchange Commission is attempting to defer the case as long as possible for whatever reason. Attorney Hogan explained the situation. If Ripple is successful in bringing those issues to summary judgment and winning on either of those issues, the case against Garlinghouse and Larson will be dismissed. In other words, Ripple asserts that, because discovery involving those two issues has been completed, the Ripple case can proceed on one track while the discovery of other issues relating to the individual defendants can proceed on another track in the meantime. In contrast, the SEC is attempting to delay the case by claiming that the Ripple case and the individual defendants' case are two separate cases. Furthermore, Ripple should not be permitted to proceed until all discovery in regard to the individual defendants has been completed. According to Ripple, if she concurs, they proposed opening briefs on May 22, which would put us on track for a decision in late summer as anticipated. If the judge agrees with the SEC, a summer 2022 conclusion to this case is probably too optimistic, he concluded. The judge recently ordered both parties to come to an agreement on a briefing schedule for the summary judgment proceeding, which they have now completed. Do you agree that this is good news? If yes, then make sure to like this video. There is, however, even more information available about the case. A wild few months have passed for cryptocurrencies, and even more so for Ripple Labs' XRP token, which has seen a significant increase in value. A year after hitting an all-time high of $1.83 on April 13, 2021, the price of XRP has plummeted by more than 54%. Analysts, on the other hand, are now noticing signs that the payment protocol coin is preparing for a trend reversal, with bullish momentum increasing in recent weeks. If this turns out to be correct, XRP may be on the verge of breaking out of its downward trend sooner rather than later. So, what is it that is causing this resurgence of optimism? However, according to recent updates shared by Ripple's defense lawyer, James K. Phelan, the long-running and contentious legal battle with the United States Securities and Exchange Commission could come to a conclusion as early as the end of next month. The request for an extension of time to file answers, which are due no later than April 8, made by the Ripple individual defendants has been granted in a text-only order, according to another update to the Ripple legal case released this week. For Ripple Labs, defendants Brad Garlinghouse and Christopher Larson have requested an extension of time to respond to the redactions proposed by the United States Securities and Exchange Commission to 4 sets of documents, notes from the agency's meetings with third parties that are relevant to the case that Finland has made available electronically. When the defendants respond, it will be clear whether they agree with the redactions or disagree with them, according to the court. The Securities and Exchange Commission has given its consent to the filing of the motion to extend the deadline for filing the motion. A letter addressed to Judge Sarah Net Byrne states that the SEC legal team is required to provide the redacted documents by the beginning of next week at the latest, unless an extension is requested. The defendants in the Ripple case have until March 28 to respond to the allegations against them. The Ripple legal team, on the other hand, has now requested that the court grant them an extension of time in order to respond to the lawsuit. On March 24, according to media outlets, the SEC filed a motion with the court in order to obtain an extension of time to make the aforementioned redactions to the notes pertaining to the Ripple case. What do you think about Ripple's chances against the SEC? Do you think we'll see a quick win for Ripple? Let us know in the comment section. If you want to continue to know about XRP, we have got 2 videos waiting for you on the end screen to check out. Make sure to subscribe and give us a thumbs up. Thank you so much for watching. See you in the next video. Kindly note that prices of cryptocurrencies frequently change, so by the time you watch this video, it might have changed to a whole new value. The information provided in this video does not constitute investment advice, financial advice, trading advice, or any other sort of advice, and you should not treat any of the content as such. The content in this video is for educational purposes only and hence should not be considered financial advice. Do conduct your due diligence and consult your financial advisor before making any investment decisions.
So enjoy your day, everybody. I'm always here for you. Leave any comments or questions below and be sure to subscribe. But thanks, everybody. I really appreciate you. Enjoy your day, and I always have your back. So thanks so much, everybody.